Technical Session 22 of the Nuclear Regulatory Commission's 37th Annual Regulatory Information Conference. And while this is labeled a technical session, unlike other RIC sessions this week, the focus here won't be on one or more of the technical issues associated with the regulation of nuclear reactors, materials, or waste. Instead, to foster a timely discussion about significant legal issues impacting the associated fields of administrative law and nuclear regulation, this session has been organized by the NRC's Atomic Safety and Licensing Board panel under the direction of Chief Administrative Judge Roy Hawkins. My name is Paul Bulwark, and I'm one of the Licensing Board panel's legal administrative judges. Sitting beside me, our panel legal administrative judges William Froelich and Jeremy Mercer. And we are serving as the coordinators for this RIC session. Before we begin, there are several administrative matters about which session attendees should be aware. You may have heard these before. For those attending in person, the Wi-Fi code is RIC 2025. Also, everyone here in Ballroom D, please take a moment to silence your electronic devices. The Q&A portion of the session will be through electronic means for both the in-person and virtual attendees. For those of you here in the session room, please take a moment and scan the QR code on the screen behind me. You will then be redirected to the specific Q&A page for this session. And if this is the first time you're accessing a session Q&A page today, as an initial matter, you'll need to log into the RIC platform using the name and email address you provided when registering for the RIC, as well as a two-factor identification code that will be sent to your email address and hopefully will not end up in your spam folder. For those of you joining online, having already logged into the virtual conference platform and to join this session, you will find there's a box on the right-hand side of the screen with a tab for electronic Q&A. Questions from both on-site and online participants will be added to the same queue, and we'll try to get through as many questions as we can during the latter portion of the hour and a half that we have planned for today's session, which is being recorded for later viewing. Also, for anyone who has any follow-up questions for our on-site panelists, they will be available for a couple of minutes, I think here in the front of the room or outside if they shoo us out, depending on what they want to do. And toward the end of the session, another QR code will be displayed, allowing those in person to provide feedback regarding the session and the conference generally. Those joining us remotely will need to click on the feedback tab in the box on the right side of their screen, provide their assessment of the session and the conference in general. With these administrative announcements completed, let's move on to the substance of today's session. For those of you who have attended the RIC administrative law sessions during the past 2 years, part of the discussion today may provide a sense of deja vu in that the issues examined then, either in the context of recently issued or pending United States Supreme Court rulings, continue to hold sway. These include the major questions doctrine as articulated in West Virginia versus EPA, the demise of Chevron deference to agency statutory interpretations under the court's ruling in Loper Bright Enterprises versus Raimundo, the holding of Jarkissi versus SEC regarding whether an agency adjudication is an appropriate forum for challenging a civil penalty action, the decision in Corner Post Incorporated versus Federal Reserve System concerning the limitations period governing challenges to agency rulemaking, and the NRC versus Texas case, argued a week ago yesterday, that in the context of the agency's licensing of 2 interim high-level waste storage facilities, posits both the procedural issue of exhaustion of administrative remedies under the Hobbs Act, as well as the question of the deference owed to the NRC's interpretation of its authority under the Atomic Energy Act to regulate nuclear materials, including high-level waste storage. And added to this are recent developments regarding the continued viability of the for-cause removal protection afforded independent regulatory agency members as recognized in the Supreme Court's 1935 decision in Humphreys Executive versus the United States. This morning's session, which is entitled Legal Impacts of the Advance Act and Recent Supreme Court Administrative Law Decisions on NRC's Regulatory and Adjudicatory Processes, potentially encompasses all of these transformational issues. Included, however, is an additional focus of inquiry, namely, how might these various developments and others affect the NRC's implementation of the recently adopted Accelerated Deployment of Versatile Advanced Nuclear for Clean Energy Act of 2024, say that quickly, better known as the Advance Act, with its provisions intended to support more efficient, timely, and predictable licensing reviews for new nuclear fuels and reactors, encompassing both small modular and microreactors, as well as the development of a regulatory framework for mass-manufactured fusion machines. Given this plethora of issues, we're fortunate to have with us today a very knowledgeable panel to provide some insight into the implications of this rapidly and potentially profoundly changing administrative law landscape. So I turn now to Judge Froelich, who will provide some background about our distinguished panelists. Judge Froelich.
Thank you. Good morning. We have a distinguished panel with us today who will share their perspectives on the ADVANCE Act and what some of the recent cases before the circuit courts and the Supreme Court mean for the future of administrative law. They'll discuss whether the federal regulatory landscape is changing and how parties may have to adapt. They'll give their perspectives on the future of administrative litigation and perhaps opine on the future of Chevron deference, the major questions doctrine, and what's meant by clear congressional authorization to act. First, we'll hear from Alina Toplinsky, a partner at Pillsbury Winthrop Shaw Pittman, LLP. She's Pillsbury's global energy industry leader and a member of the firm's international nuclear projects and hydrogen team. She focuses on international nuclear energy matters, including advice to U.S. and global clients on transactional and regulatory issues. Ms. Toplinsky received her Bachelor of Science in Foreign Service, International Politics, and International Law from Georgetown University, cum laude, and a JD from Fordham University School of Law. Next, we'll hear by video from Dr. Victor Galinsky, a physicist and former commissioner of the NRC during the Ford, Carter, and Reagan administrations. Before his nomination to the NRC, Dr. Galinsky was a special assistant to the Atomic Energy Commission's Director of Regulation. And before that, he was head of the RAND Corporation's Physical Science Department. Dr. Galinsky was also a director of RAND Corporation's Applied Science and Technology program. He received his bachelor's degree in engineering physics from Cornell University and his PhD in physics from the California Institute of Technology. Next, we'll hear from R. Bud Hamer, Senior Nuclear Counsel for the American Electric Power at its D.C. Cook Nuclear Power Plant in Bridgman, Michigan. Prior to that, Mr. Hamer was a lawyer with the nuclear energy practice at Pillsbury Winthrop Shaw Pittman. Mr. Hamer is also a professorial lecturer in law at George Washington University School of Law, where he teaches nuclear energy law. He's also an adjunct instructor at the Lake Michigan College and teaches energy and business law topics. Mr. Hamer earned his Bachelor of Science Chemical Engineering degree from Washington University in St. Louis and his JD from Georgetown University Law Center. Last, but certainly not least, we'll hear from Professor Emily Hammond. Professor Hammond is an environmental engineer and a nationally recognized expert in energy law, environmental law, and administrative law. Professor Hammond's articles have appeared in the Columbia Law Review, the Duke Law Journal, the Michigan Law Review, and the Vanderbilt Law Review. Professor Hammond is also a member of the Administrative Conference of the United States and an elected member of the American Law Institute and past chair of the American Association of Law Schools Administrative Law Section. Professor Hammond received a BS from Virginia Tech and a JD from the University of Georgia. Okay, with that, Alina Toplinsky, please take it away. Thank you.
So much. Thank you so much, Judge Froelich. Thank you for the opportunity to be here, and I'm glad to see that we have so many people in the audience. Some of us thought we would be talking to an empty room, but it's great to see that there's so much interest on the legal and regulatory side of things, including the ADVANCE Act. So you can probably hear from my bio that some of my focus over my career has been international, and it's been very interesting advising clients here in the U.S. On their engagement with the NRC and getting through the NRC licensing process, but then going overseas and working with countries developing new nuclear programs where the regulatory bodies are being designed from scratch, where we're drafting some of the regulations, as well as looking at some other mature markets and how they handle licensing. It causes you to think a little bit about how the NRC regulates, and also a very unique legal system in the United States. I can tell you from all of the jurisdictions where I have worked, I've never seen something akin to the Administrative Procedure Act. And a lot of how we regulate here is really because of the APA and the engagement that we have as part of the APA. But it's important to know that despite the fact that we have these very firm requirements under the APA, and of course a lot of procedural as well as case law history, there are ways to think outside the box a little bit and have the NRC fulfill its mission to ensure adequate protection and public health and safety, but adapt to this new changing world where we have new types of technologies coming to the fore, new applications and new uses of the technology, and be able to meet the mission while also advancing the beneficial uses of nuclear energy. And I think that is what the ADVANCE Act tries to do. I've had the opportunity to work on and suggest some language for some portions of the ADVANCE Act. So in my remarks, I'm just going to focus on some provisions of the ADVANCE Act. It is a 30-plus pages of legislation, so I can't go through all of it. But I'll focus on some sections which I think are interesting and talk a little bit about how the NRC is implementing these sections. So a lot of discussion, and I think this has already been had as part of the REC, has been on the NRC mission statement, which there's also, I understand, a public meeting later today where the NRC is going to be talking a little bit more about the mission statement and how they're interpreting the mission statement. But the ADVANCE Act, at Section 501, requires the NRC to update its mission statement to include efficiency as well as the beneficial use of nuclear materials and the deployment of nuclear energy and nuclear technology. And the NRC updated that mission statement on January 24th of this year. So the old mission statement was pretty focused on the language that's already in the Atomic Energy Act. It stated that the NRC licenses and regulates the nation's civil use of radioactive materials to provide reasonable assurance of adequate protection of public health and safety, to promote the common defense and security, and to protect the environment. So the new mission statement contains those elements. Those elements are still there. The NRC talks about protecting public health and safety, advancing common defense and security. There is the benefit of society and the environment, but there are two elements in between, which is the enabling of safe and secure use and deployment of nuclear energy technologies and radioactive materials. That is really supposed to go to the timeliness of the NRC process, as well as the inclusion of some of these new technologies, as well as new uses of existing technologies. And then you've got the second part about efficient and reliable licensing, oversight, and regulation. That's really the focus on performance and project management. And this is, both of these elements, the timeliness and inclusion of new technology, as well as the performance focus, I think have been part of what the NRC has been striving for a number of years. The NRC puts out milestones. It does try to adhere to schedules, but in this mission statement, there is more of an emphasis of we're still going to regulate to ensure adequate protection. We're still going to have this North Star focus on health and safety, but we're going to think about how to do that in a timely way, in an efficient way, how to best manage our resources, and how to ensure that the licensing reviews are conducted in the best way possible. Of course, the devil is really in the details. It's always interesting to be involved in legislative drafting. There's lots of blue sky concepts, and there's lots of wishful thinking. But unless you really know how the process works, how the reviewers interact with each other, how projects are managed within the NRC, as they would be in any organization, it's really hard to achieve those goals without attention to the detail. So I think all of us, who are involved in NRC licensing are going to be closely watching the implementation of this mission statement and seeing how the agency handles some of these, very good aspirational aspects of that mission statement. So let's go to the next slide. Nuclear facilities and brownfield and retired fossil sites, I think, is a really interesting one because there's been so much discussion over the past couple of years on reusing existing sites. Most of the focus has been on coal to nuclear. So the Department of Energy has done a number of studies. One of those studies looked at least 11 states being interested in transitioning existing or decommissioned or in the process of decommissioning coal sites to nuclear, whether it's advanced nuclear or even some of the current light water reactors. And there are 300 sites that are potentially eligible for something like that based on what the DOE found. And that would add at least another 150 gigawatts of nuclear capacity and exceed the capacity that those coal plants, even when they were operational, were currently providing. So there's a lot of interest in this, a lot of interest from a community engagement standpoint, right? These are jobs that are being lost by these communities. The communities are being devastated by that. Nuclear jobs pay much better than coal jobs, and of course are better for health and safety as well. There's a lot of discussion about reusing existing infrastructure, both in reusing the transmission infrastructure and of course the labor, retraining the labor, but also some interesting concepts posed by reusing some of the sort of the balance of plant of the existing coal-fired or other fossil fuel sites, and being able to shorten the construction process of a new reactor by doing that. So lots of interesting concepts being proposed, but of course the key question is, how do you license something like this? How do you license a new advanced reactor, let's say, at a coal site? So this is Section 206. Of the Advance Act that requires the NRC to first put together a report to Congress within 14 months on modifications to existing regs, guidance, and policies needed to enable the efficient, timely, and predictable licensing, review, and oversight of nuclear facilities in brownfield and retired fossil sites. It's important to note, what is brownfield? That's the definition from CERCLA that is being used. So it's any site, not necessarily that it's contaminated, but is also not clean. It's a brownfield site, as I think most of us will commonly think of that site. And a brownfield site also importantly could include a decommissioned nuclear site. So we had nuclear power plants, but no longer they're operating, but we can use some of the elements of that site. And then within 24 months of the enactment of the Advance Act, the NRC has to either develop strategies to enable the timely licensing or initiate a rulemaking to that effect. And all of those things that I talked about, the use of the existing infrastructure, looking at previous NEPA reviews, thinking about water availability, thinking about heat sink components, steam cycle components, and reusing some of the existing components on site. The NRC has to consider all of that. And there are lots of opportunities, right, to shorten the timelines for licensing by using these existing sites. Of course, there are some difficulties as well. If you have a site that is contaminated, like some of the coal sites, you actually have to have the cleanup, and that goes to the financial assurance issue. So there are some challenges, but there are also lots of opportunities, and the NRC is looking how to use those opportunities to speed up the reviews. The next one, new reactors at existing adjacent sites. If you could go back one more slide. I think we advanced too fast. But I think all of the utilities that are in the room will feel very close to this one, because as you go through these licensing reviews and you think about, why should it really take 3 years to license a new reactor in an existing site when all of the site characterization elements have been done. You've got all the past NEPA reviews, and especially if you have a reactor that's based on a certified design, right? Especially if you have a design cert, but even if you've had a previous construction operating license or an operating license issued, or the manufacturing license is also included as one of the elements. There really should be a shorter review period for that. So, I think this one is pretty straightforward. The NRC is given sort of a shorter time frame to issue an SER and complete an EIS or an EA, complete public hearings, and then issue a decision on license within 25 months. I frankly think, just from experience, it's something you could probably do faster than that given these elements of a certified design or an existing a design that's gone through an existing review at an existing or an adjacent site. Let's go to the next slide and talk about microreactors. So microreactors, of course, are very interesting. They're sort of all the rage now, right? If you just hear what people talk about in the public, especially as we think about new uses of nuclear energy. This week is also Sarah Week in Houston. So all of the oil and gas interests are there. And it used to be that no one talked about nuclear at Sarah Week. And now everyone's talking about nuclear. And especially people are interested in microreactors. They're interested in those reactors because they can potentially be manufactured much faster. They can be installed. They don't need a complicated construction process. And they can also kind of fit to scale of what some of the oil and gas companies need, and other industrials to support their operations. So there's a lot of hope being placed in microreactors. But of course, if we license microreactors, that are 5, 10 megawatts, or some are even less than that, using the same process that we currently use large reactors, some of the utility of those microreactors disappears because, if you could deploy it in a year, but it takes you 6 years to license, that's not a great proposition. So there have been lots of proposals, by industry, by think tanks and others, looking at microreactors more like we look at research and test reactors, considering some of those safety elements, considering that some of the elements that are currently in the regulations should not apply. And that's what Section 208 seeks to do. NRC has to establish within 18 months a performance-based and risk-informed approach for regulating microreactors, and then within 3 years, the NRC has to implement that approach. And the ADVANCE Act provides lots of flexibility in how the NRC can do that. So they can either use the existing framework and provide exceptions for where this doesn't apply. It can implement this through Part 53, and we're not going to talk about Part 53 today because that will be a separate presentation. Or it could be a whole new rulemaking, and I think there are diverging opinions about which way is the fastest way. If we go to the next slide, next section that's interesting, I think, are the NEPA reviews. It's Section 506, and the NRC is basically required to update and streamline the environmental review process for reactor applications. And I think it's very interesting mandate that was in place before we knew what is happening today, which is the executive order that was issued a few weeks ago called Unleashing American Energy. I've got Section 5, which revoked the previous Carter administration executive order directing CEQ to issue binding regulations and directed the chairperson of CEQ to rescind all CEQ NEPA regulations and issue new guidance to federal agencies. So the CEQ is in the process of doing that. They've proposed an interim final rule, which is going to go in effect in 45 days. At this point, it's less since they proposed it, but about a month from now. The CEQ regulations have now been essentially retracted, and the agencies are required to implement their own NEPA regulations. And the guidance that's been issued by CEQ as part of this interim final rule also gives some guidance to regulatory agencies on what they should think about as they implement their own NEPA regulations. So it'll be very interesting to see how that element of this now new executive order, as well as this soon-to-be final rule, comports with this section of the ADVANCE Act requiring the NRC to streamline NEPA reviews. So that's I think for all the lawyers, all the NEPA lawyers in this room, that's one to watch very closely. Let's go to the next slide, please, and I'll just quickly talk about foreign ownership, control, and domination. This has been a big topic for the industry ever since we had the first attempted nuclear renaissance, and we had several issues where the FOCD requirement was a barrier to developing new nuclear capacity, specifically at Calvert Cliffs, where you had Unistar that had French ownership that was not allowed to proceed with that project, as well as the South Texas project, which had a very small ownership of Toshiba, a Japanese company, but because they were sort of the main investor, they were deemed to have control over that project, and they were not allowed to proceed. So this is something that really, I think the industry remembers as being a big obstacle in developing these reactors. And in these two particular cases, at Calvert Cliffs and South Texas, you had two countries that are very friendly with the United States, right? Japan and France. And you already have an existing inimicality requirement, non-inimicality requirement in the NRC's regulations. So I think a lot of people felt that the FOCD requirement was duplicative. Certainly, the NRC should consider whether proposed control or ownership of a nuclear facility is inimical to the interests of the United States. But this FOCD requirement basically implemented that twice. And create a lot of issues. So this new Section 301 essentially removes that element with respect to countries that are members of the OECD, which are generally countries very aligned with the United States or India. So there's potential for majority ownership of U.S. nuclear plants by entities in 39 countries. And we still have that inimicality standard. So I'm told I have 2 minutes left. I think I have just one slide left to quickly mention, and that's advanced nuclear fuel concepts. It's, of course, part of the discussion. I just wanted to mention this one because Advanced Act is not just about reactors, it's also about the supply chain, and the use of advanced fuels has been a big part of the discussion. How do we license these fuels? What are some of the actions required? What collaboration is needed between the DOE that's doing a lot of work on the R&D side of these fuels and the NRC? So there are some specific milestones provided for the NRC to do that. And with that, I'll close out my presentation. Thank you for your attention. I appreciate it.
All right, Mr. Hamer?
Yeah, Bud?
Oh, I get to go now.
You.
Okay,
Yep.
great.
Oh, Kalinsky, I'm sorry.
Kalinsky,
Yes.
my apologies, Commissioner.
All right, there he is.
Can you hear me? Shall I go ahead?
Yes.
Okay. Well, thank you for including me. I thought I could best contribute in this session about the Advance Act by providing some historical background in having been here at the beginning, so to speak. The purpose of the Advance Act, as Alina mentioned, is in its title, it's to accelerate licensing of a new generation of fast reactors. Title V on efficiency calls for a new NRC mission statement that specifically includes not unnecessarily is in quotes, limiting the benefits of nuclear energy. It sounds innocuous, but it's loaded with meaning. And this is what I want to talk about. It's unusual for Congress to direct an agency's mission statement, maybe even unprecedented. NRC has been efficiency conscious for years. Commissioner speeches make frequent references to it. So you might think Congress is just urging NRC to press harder. But of course, that isn't so. Congress is swinging a legislative 2x4 to get NRC on board fast with the Energy Department's effort to launch advanced reactors. Here's the irony. 50 years ago, the 93rd Congress created the NRC precisely to avoid this kind of pressure on safety regulators. The old Atomic Energy Commission had been leaning on its regulatory staff to speed licensing of commercial reactors. Internal conflicts exploded over the safety approach to the agency's main project, which was then a prototype fast reactor. The public became worried about nuclear safety. That got the attention of Congress, which worried about public support for nuclear power. Ergo, they created an independent NRC. Incidentally, forgive my voice, I'm getting over a cold here. The ADVANCE Act deals with safety by telling the NRC, while speeding licensing, to remain consistent with the Atomic Energy Act safety standard. But this nod to safety is very much outweighed by the references to timely, efficient, and predictable licensing. People in the bureaucracy react to management incentives. If promotions go mainly to those who speed licensing, you will get faster licensing, but safety will suffer. Of course, the law is the law, and the NRC has to follow Congress's dictate. But I think the commissioners need to talk to the senators who drafted the ADVANCE Act to work out an interpretation that gives the NRC the flexibility to put more emphasis on safety than is the sense of the act. Let me step back for a moment on how we got here. No fast power reactor is operating in the country, not even a prototype. But the Energy Department and nuclear industry have great hopes for the technology, and they're in a terrible hurry. They convinced Congress that the main obstacle to wide-scale deployment of the new reactors isn't the product, but the NRC safety licensing. It's too slow and too demanding. They insist nuclear power plants are safe, the new ones will be safer, and that should be good enough. To make sure congressional intent isn't lost on the NRC staff, the law instructs the commissioners to issue guidance to make sure the staff understands, in effect, that the time they take to review a reactor license is time that delays nuclear electricity. But you know, the safety professionals don't need to be told. They understand. The people who don't understand, in my view, are the law's drafters. I doubt they have any idea what nuclear safety evaluation is about. It would have helped if they had held hearings. People often say glibly that nuclear power is safe. But if it were intrinsically safe, we wouldn't need the NRC. Nuclear power is intrinsically dangerous, like safe flying. And like airplanes, reactors are safe when operated within certain limits. And choosing those limits takes a high level of professional expertise, and so does enforcing them. The new fast reactor designs have safety pluses, but they also have safety minuses. NRC needs to proceed carefully, especially at the outset. If, as sometimes happens, safety assumptions turn out to be wrong, we want the NRC experts to catch that. The commissioner's top concern should be to assure that the staff is properly motivated and equipped to thoroughly examine safety issues. For an example of how things can go wrong when the safety message from the top is not clear, consider the case of Boeing, which is in big trouble, as we all know. It also isn't obvious that DOE's optimism about commercial prospects is justified. This isn't the first time we've been chasing fast reactors. They were the old AEC's main project 50 years ago. The AEC expected hundreds of these plants to be built in short order, but not one plant was built, none such plant. Glenn Seaborg, who was then AEC chairman, later wrote that all the economic and technical assumptions underlying the program proved to be wrong. There was another fast reactor push during George W. Bush's term. Nothing came of that either. We're all familiar with enthusiasts from baseball to the stock market promising this year it's different. Well, sometimes it is, and sometimes it isn't. As to improving safety, NRC safety reviews, That is always a good idea. But to improve the process, you need an expert understanding of it. And whatever you do, the resulting safety standards should go up, not down. It troubles me that in recent years, the NRC commissioners have stopped using the Atomic Energy Act's safety standard, adequate protection of the public health and safety. They switched to a weaker standard, reasonable assurance of adequate protection. The Advance Act picks that up, so when it tells the NRC to be consistent with the Atomic Energy Act, it means consistent with that weaker standard. It's for you lawyers to sort out, but it seems to me the Act has thereby lowered the statutory nuclear safety standard. Let me just end here with a quote from Mo Udall, a great Arizona congressman and a wise chairman of the House Interior Committee in NRC's first years. He said, "A respected NRC was essential, a sine qua non for public support of nuclear power. In my view, the Advance Act undermines that respect." Thank you.
Okay, thank you. Switching now. Bud, it's yours.
And they gave me the steering wheel, so I hope it works. There we go. Thank you. Thank you, Judge, for the invitation and the fine introduction, so I won't go over who I am again. I've got 10 slides. I'll hit them in 10 minutes. We'll be great. 3 subjects. The first one is jury trials. We'll start with something easy, and then we will not get off of Advance Act 501. Alina explained the whole depth, but I want to take 2 issues, one very much up with the angels and one down very much in the weeds, to sort of show how much effort a lawyer can spend on one paragraph in an act. I mean, Commissioner Caputo was kind of frustrated in her remarks about how much effort lawyers spend on a word. Wait until she finds out how much we like comma placement. All right, as mentioned, I do have a day job, and there's a lot of activity going on it. I am not going to talk about it. Communications did not approve me to do anything but put this slide up. The difference between the day job and what I'm going to talk about, which is being an adjunct instructor at GW, is that in my day job, I've got to answer questions. As a professor, I only have to ask them. And so we'll get through sort of that view of how do we form questions, how do professors come up with questions. And with that, I hope you'll get some sort of understanding of the depth and complexity that the Advance Act has put up there or the opportunity for lawyers. All right, jury trial. The SEC thought for a long time they could just issue fines without a jury trial. That certainly created a lot of news last year when the Supreme Court said not. This slide is organized on the issue, rule, analysis, conclusion style that advocates use for talking to judges. As I mentioned, I'm going to end at the questions, so there are no conclusions. The first bullets there lay out the rule. The rules haven't changed, but when we get down there, you'll see perhaps what changed last year. All right, let's take it from the NRC standpoint, from a practical standpoint. You're sitting in your office, and a regulatory licensing person comes into your office, or the VP, and they say, "We've got a white finding. It's going to cost me $250,000 to respond to the special inspection. What can you do for me?" Well, the answer is lots of things, because when my day job, when I have to answer questions. But on this category, the answer is going to be, in terms of getting a jury trial over that, none. This is the government acting as the government. The government has decided what it wants to spend its resources on. It has prioritized that issue as being white level, and therefore, so even though it's going to cost you money, there's not very much we can do about it. It's really not enforcement. Second issue, which more often comes up when people do something wrong. They get their license conditioned. Operators will get their license perhaps revoked. People might get banned from the industry for 3 years or 5 years. I will just say that I've been getting emails for the last month because Cook is going into an outage, and I am surprised how many people don't know that we do fitness for duty testing before they come in. But anyway, so they get those bannings. If you look at the rule, the first rule is action at common law. A ban is primarily an injunction. It's very much, if you're thinking about what the King of England did in 1790, which is the standard for the Seventh Amendment, that was more of an injunction. That was more of the king that was not an action at common law. And so most of those actions which run into how the NRC typically responds to these issues, conditioning licenses or bannings, is not going to get you a jury trial. The last one, monetary penalties. And this is, generally speaking, what the NRC does when they issue a monetary penalty. It is a penalty. It's not an effort to collect money to make up for, extra expenses. It's designed to punish. And here the question is that a monetary penalty? Is that pursuant to a public right or a private right? And this is where the recent SEC case comes in. Previously, it was sort of the standard of, well, is that what the agency does? Is the agency doing what the agency does? Then therefore, that's a public right. Now we're more looking at what is the view from the person who is being impacted by that. And that's sort of the shift. So if this is a penalty that would sound in common law, yes, you might be able to ask the NRC and get it's a question to ask as to whether or not you could possibly get that. So if you think about it, right, I mean, the question used to be, the agency is a spider pig. Is the agency doing what spider pigs do? Well, then you're done with your inquiry. On the other hand, now you have to say, what's the impact on the homeowner of having muddy hoof prints on the ceiling? And that's sort of the difference in standard. Anyway, those are the questions you can ask. And I will just say the last thing on a practice point, which is that usually a legal person gets a jury trial if a natural person does, but any good lawyer knows that you've got to go make sure that there isn't some special circumstances. Anything else I got on my list here? All right. Okay. So let's go to Advance Act 501, and like I said, we're going to try and go up to a very high level. I will say that both of these issues that I'm going to go through are informed by students of mine. I asked the question, they got to write a paper answering the question, and I won't bury the lead, they got A's, so, but anyway. But let's start with the Advance Act, and these are, obviously I'm not going to try and be comprehensive. I've picked 2 words to try and show the scope of it. Enable, I've put in green. It comes out of the Act, you can find it in the Act. If you read the vote sheets, there's a long discussion about the importance of enable and what it means. So on the categories under what is called Skidmore, which is the 1944 case that springs back up now that Loper Bright has gotten rid of Chevron. And the reason I emphasize 1944 from a practical standpoint is that predates the APA, which Loper Bright is based on. So there's a lot of room to ask questions. Has life changed since 1944? I don't know. I mean, has it? Nazis are still bad, right? I mean, I don't know. Anyway. But anyway, so here are the 3 tests out of Skidmore. Those are the ones that are going to be applied. That's what you're going to have to be thinking through. And so clearly enable is going to be a lot of degree of care. It comes from the statute. The agency's position for putting enabling in there is fairly persuasive. And there's a good memo from OGC that sort of laid all that out, and so the agency was well informed when they put enable. I will say, if you're a commissioner, disagreeing with your lawyer is probably not the best way to get through these statutory analyses, but anyway, I see Brooke back there. I don't know if I'm going to. I'll give a plug for maybe you should listen to the OGC or at least ask them to resubmit their opinion so that it matches what you want to think. Anyway, those are the sorts of issues that are going to get, because Skidmore, under Skidmore, the question about whether or not you thought hard about this and whether or not you had a legal opinion is going to matter on your interpretation. Anyway, and the flip side of that then is the ones I put in red. I assume the benefit of the environment goes over the word and, because just regulation of the environment sounds like, I don't know, Dr. Seuss and the Lorax who speaks for the trees. But the statute says protect. Is benefit the same as protect? Well, lots of room in there for to argue the difference between protect and the difference in standards between protect and benefit. I mean, for example, carbon dioxide, right? Emitting carbon dioxide is obviously bad for the environment. Reducing carbon dioxide will be a benefit to the environment. But if you're going to write a paper, you can probably find a bunch of experts that will say that perhaps emitting carbon dioxide is not necessary to protect the environment, particularly if they were going to read some of those EPA decisions that are coming out this week. So anyway, so that's sort of the scope of the questions that you can possibly have. And I'm not saying that anybody would necessarily, like I said, these are just the questions. I'm not trying to give you the answer. And Commissioner Galinsky mentioned the reasonable assurance standard put into the Advance Act. And I will say that originally, if you go back to Power Reactor in '57, the reasonable assurance was a finding made by the Commission, finding number 22 in that license. And if you look under the APA, findings of fact are where the agency has the most power. It's most clear. And then you have the regulations, and I don't know if we're going to get into Auer and Kaiser on the NRC's ability to interpret its own regulations, but it was also in the regulations. Now it's in a statute. And as you look at my little illustration of a seesaw, under law, the statute, certainly in the post-Chevron, Loper-Bright world, courts feel like they have the most power. All right. Did I go? Okay, so let's give the first question. The restart of TMI Unit 1 in the 80s was the subject of the student picked, and it was what if somebody was to think about restarting TMI Unit 1 again, hypothetically, how would that NEPA suit come out? And he came out with the answer is that NEPA law has evolved, and yes, you would expect the answer would be the same. You wouldn't get very much on NEPA. And I would say you could stop there on the NEPA, but it does leave you an interesting question if you delve further into it, which is that original Met Ed decision has footnote 5 in it. And footnote 5 is one of those great, I've got them up there, one of those great ambiguous Supreme Court decisions. Nobody asked us, does that mean we would have said yes, or does that mean we would have said no? You can read yourself into that as to whether that's the closing the book on the issue or opening the door for the question. Interesting question to go think about. And for that, I will then say that I think there's the opportunity, contrary to what Commissioner Galinsky observed, for the Commission to do more safety, reasonable, or people to advocate that the Commission and should ask the courts to require the NRC to do more safety, because reasonable assurance is now something that is not just a finding of fact made by the Commission, but is in a statute subject to interpretation by Article 3 judges. Okay. Anyway, so like I said, the question is it still no? It was no in footnote 5. Is it still no? Second question. This is probably more along the lines of agreeing with Commissioner Galinsky. Does the NRC have to consider costs in its safety decisions? Certainly, Commissioner Marzano has in his vote sheet the words in there. Loper-Bright quotes favorably Michigan versus EPA, which has a finding about reasonable regulation needs to consider cost, even if cost is not necessarily explicitly in there, and that's an EPA statute. And at your leisure, you can read Justice Kagan's war of the analogies, the metaphors. I think she wins over the majority opinion on the metaphor war, but remember it's a dissent, so it only goes so far. And I will say this, that personally, if I think the car's brakes are bad and I don't know how to fix them, I'm not sure I want to be driving around in the car. And I certainly don't want people operating nuclear power plants to be doing that. If you go back to emergency core cooling systems for after 3MI. And I will say that perhaps I had Justice Kagan's view of driving around with bad brakes prior to surviving an accident on the George Washington Bridge. Now I have a lot more there. A lot more religion about the concept. All right. This has this huge broad scope. As mentioned, there's a meeting at 1 o'clock to talk about more of it. I don't want to try and say, I just want to say I've gotten into one little tiny aspect of it, and we have a tremendous amount, certainly not trying to be comprehensive. And I'll shout out to Rama, who I had the pleasure of having in my class. If you've been to either the first Chairman Wright meeting, which was on the ADVANCE Act, or some of the remarks made like yesterday, they've all mentioned the Columbia report that Rama is a co-author of. So I wish I could take credit for his genius, but he also took the NEA International Nuclear Law course that I saw Steve Burns here earlier. Yep. So anyway, I'll just leave these slides on sort of a questions for you to go look at as we go through. I mean, environmental justice, there are a lot of studies being done on environmental justice. The paper that I gave an A2 on this subject was highly critical of the NRC's view. The commission overturning the idea of doing environmental justice for discrimination doesn't necessarily make it certainly opens the idea to questions. Why are you doing an environmental justice review if it isn't related to if it isn't related to discrimination? And so anyway, so here are the memos, I will say. And to the extent of the ADVANCE Act wants to sort of change the way the NRC approaches it, the environmental justice is 18 months of an NRC study, a SECI that went into the commission that is still sitting. Commissioner Caputo will admit that it's on her desk. So that's where it sits. And NEI has got an environmental justice to go look at it again. And you can continue to go on and think about it. The question that comes up is you want to think about it. And if you go down, I mean, there's a low-income aspect to environmental justice, but if you look at just race, there's a lot of opportunity to take some of the principles that were applied in Fair versus Harvard for admissions programs and then say, to what extent are they analogous to an NRC licensing proceeding? To what extent do those rules apply? Are they relevant and appropriate? Should you use them? Interesting questions. Maybe next semester some students will go with that. So I will leave those as questions if you guys have questions. And there we go. Do you want I don't know.
Professor Hammond.
All right, thanks so much. It's wonderful to be here back with many of you, and so delighted to be on this panel today. I thought I would, well, in thinking about how to say anything that I want to say about administrative law in 10 minutes, I'm a bit baffled as to how to cover that all, but one thing occurred to me. I think it's useful if we want to understand what's going on in the courts right now, particularly in the Supreme Court, useful to think about the philosophies of agency behavior that we see animating judicial doctrines, and this has been true for well over 100 years, but we are seeing a shift, and I think it's important to identify what that shift is because it helps explain and potentially predict some of the cases that have been making their way through the courts. So just to say a few words about that, as we just heard from Commissioner Galinsky, the NRC itself was born during a time where there were concerns about agency capture. The concern being that somebody needed to regulate safety because the industry wasn't doing a good enough job at managing safety itself, and the idea that the AEC was too cozy with industry. So we see a lot of judicial doctrines at the time, whether or not you agree with the idea of agency capture, reflecting that understanding of agencies. And so that's where we see things like the hard look doctrine emerging, the idea from the State Farm decision that courts are going to take a hard look at agencies' reasoning that they use to justify what they do. At the same time, we've seen for a very long time, at least since the progressive era, a judicial reluctance to engage deeply with agencies' expertise. And by that I mean to really dig in and second guess an agency's application of its expertise. And this, of course, you see reflected in the Baltimore Gas decision, where we get this idea of super deference, that the court should be at its very most deferential when an agency is applying its special expertise, in particular with the NRC. So we have those themes in place, and a number of them you can sort of see them continuing and how the Chevron doctrine evolved, and indeed even in one of the justifications for Chevron being about comparative superior expertise in agencies. But if you want to look at a statement that reflects what we're seeing in the court now, I invite you to take a look at Justice Roberts' dissent in the City of Arlington versus Texas case. And here you see him very concerned about a giant, sprawling administrative state that threatens people's liberty. So I just want to say, this is not something that I am necessarily agreeing with, but this idea of the administrative state threatening liberty is becoming increasingly powerful in a number of the justices' decisions as they look at particular issues of administrative law. And so if that's your concern about agencies, you can see why the Supreme Court would say, we don't think we should be deferential to their statutory interpretations, particularly when the agency is looking to expand its authority in some way. And so I think this attitude, this judicial attitude toward agencies is reflected in the overruling of Chevron and the Loper-Bright standard now that just puts Skidmore in place. It's also reflected in the major questions doctrine, which was spelled out at least in West Virginia versus EPA. And it's reflected in two ways in that case. The first one is just this idea, of course, that was during Chevron. So major questions is a big exception to Chevron when a court will not give deference to what an agency does. But I'd like to also underscore that West Virginia should have been moot. That was a situation where the court was reviewing President Obama's Clean Power Plan. It had long come and gone, and under the Biden administration, the EPA made a very strong argument to the court that it was not following that anymore, that it was working on its own approach to the carbon dioxide emissions of power plants. Even though that was a moot case, even though even a decade ago the court would not have considered that case, it did. And so if we think about not just the doctrinal rules that are emerging, how does a court review what an agency does, but also the court's willingness to step in and review what an agency does, I think we can trace both of those kinds of developments to this changed judicial attitude about what it is that agencies do and what they threaten. So let me just say a few words about what's left in terms of deference, and I thought I might also mention some things about independence of agencies and perhaps the NRC versus Texas case as well. So what do we have left after Loper-Bright? As we just heard, we do have Skidmore, and I do want to say Skidmore never died. Skidmore has been in place since it came out in the sort of post-New Deal era. It has applied to things like agencies' amicus positions when they've submitted amicus briefs. It has applied to agencies' statutory interpretations in their guidance documents. So I want to emphasize that there's a lot of case law, including contemporary case law, for those who are wondering how Skidmore works. I recently collected quite a bit of this with respect to amicus briefs in an article that was published in UC Davis Law Review, and I think I've provided the site to that. And I'll say, we might call it deference. It's not very deferential. Let me just be clear about that. Yes, the agency's application of its expertise is relevant. Yes, an agency's long-standing statutory interpretation is relevant, but ultimately it still comes down to what the court thinks is the best interpretation of the case. So I don't see a lot of hope for deference to legal interpretations, even if we look at what do we have left with Skidmore. Yes, there's also still our deference, which is extra deference to agencies' interpretations of their own regulations. But once again, the Supreme Court has whittled that down, and it relies on factors that look a lot like Skidmore. So notwithstanding that the agency's expertise is relevant, it still depends on whether the court is convinced by what the agency did. There's another line of cases, though, and I've mentioned this already, that I think is still in place. And I want to highlight it for those who are serving as counsel to NRC in particular. And that is that Baltimore Gas line of cases, where we do still see alive and well that courts at some point are reluctant to second-guess an agency's application of its expertise. And I think a great example of how this plays out nowadays comes from the line of cases involving the waste confidence decision updates and then the continued storage rules. There you saw the D.C. Circuit not convinced by the agency's consideration of the risk of pool fires, not convinced by the agency's sort of, as the court said, failure to evaluate the fact that Yucca Mountain did not look like it was going to be opening. But once the agency did that, the court refused to further second guess what the agency had did. And I think that's a very representative example of how courts engage with agency science and expertise that does allow for some deference, provided the agency sufficiently justifies its decision-making. And I do have sort of an analysis of those kinds of cases in two places. One is an older law review article that was published in Columbia Law Review. One is a newer one that anticipated the demise of Chevron, and that's in the George Mason Law Review, and those are also in your materials. So that is still there. This idea of deference to expertise, provided the agency explains itself. So let me shift a little bit. I think there are a few places I could go here. I do want to just say one of the things that I'm keeping an eye on myself for NRC versus Texas is this issue of exhaustion. Looking at the oral arguments, I do see the challengers to the license making a lot of effort to convince the court that there's something wrong about the agency being able to somehow decide who ultimately can avail themselves of judicial review. This, to me, looks a lot like the same kinds of arguments that we have seen in that City of Arlington decision. This idea that if we think agencies overstep, we should make it easier to challenge them in court. So this is, for me, a concern. I think just a couple decades ago, this would have been easy. The court would have easily kept this out on exhaustion grounds. And now we're seeing real engagement with the possibility that if the agency gets to define who challenges it, that is too much of an exercise of power. So this is an issue that I'm keeping a close eye on, and even before we get to the merits, I think could well come out in a way that reflects this evolving judicial attitude toward agencies. Let me say as well just a couple of things about, I think I'll talk about the independence of agencies. We, of course, have seen the executive order from the White House that insists that all of the independent agencies are now required to engage in all of the processes of OIRA oversight. This generally has applied to rulemaking for the executive agencies. I just want to say it's not only rulemaking. I was an appointee for the Biden administration at Department of Energy in the Office of General Counsel, and these are my own opinions, but I found that OIRA had a lot to say about lots of the things we did. They called a lot and exerted significant political influence in the agency's work. What could this look like for NRC? Well, it could look like the White House calling and saying, I'm sorry, you're just not, we just forbid you from considering environmental justice issues in your NEPA analysis. We insist that your NEPA procedural rules must prioritize speed. So I just want to say this is very concerning to me, especially with an agency that regulates safety and that makes technical decisions. The more the door is opened to political influence, the more difficult it is to do your jobs. So I do see a real concern there with this issue. So that's the executive order. President Reagan also considered putting independent agencies under that White House review process and didn't do it. At the time, there were concerns about the constitutionality of that because of the way Congress had constructed independent agencies with the purpose of being independent. Now, of course, we're seeing a shift, and we're seeing that judicial attitude shifting too. You may remember then Judge Kavanaugh in the In re Aiken decision had a lot to say about his concern that independent agencies were not a constitutional structure that Congress should be able to create. Of course, now we see him in a different role where we're seeing challenges to the for-cause removal protections of commissioners and board members starting to come up through the courts. So whereas once upon a time we might have expected the courts to protect that congressional design and that purpose for independent agencies, now that's an uncertainty. I have a lot of concerns about that because I'm strongly committed to the missions of independent agencies and the need for independence there. But I want to also just acknowledge, as we're looking at what is going on now, this is all part of this bigger perspective on the administrative state that means things are shifting. So maybe I'll pause there. I'm very curious about questions that people might have and would love to be able to have all of us engage with those who are listening.
Maybe I can go directly to the point. Do you think Humphrey's executor is going to need an executor to oversee its demise?
I would love to see Humphrey's executor stay in force, even if the original reasoning of it isn't. But just because I think it's important, I think it should still matter that Congress had good reasons for constructing some agencies that way. I think it's pretty clear that we have at least 3 justices that would easily vote to overrule Humphreys, and I'm not sure how some of the others might go.
All right, well, thank you very much to all of the panelists. Very, very informative discussions. And I'm wondering if we could possibly bring back Commissioner Galinsky, because we have a couple questions where I think his expertise or his views might be relevant to answering them. And while we're doing, welcome back, Commissioner Galinsky. We have a question that came in, and I'll throw this to you first, Commissioner Galinsky, and then anyone else on the panel who wants to weigh in. The question is, combined with the directives of the ADVANCE Act and various judicial decisions, the regulatory landscape appears less stringent and lower safety standards. While it makes sense to see certain changes in favor of loosening standards, is there a concern that the overall outcome, when it all shakes out, could be an indiscriminate decline in level of regulation? And what can the regulators do to ensure that when we say risk-informed, we're not using it as a euphemism to lower standards? Now, Commissioner Galinsky, that's the question. Whether you agree with the principle or the basis of the question, I'm not sure. But if you've got any thoughts on that, we'd be happy to hear them.
Well, it's sort of a complicated question, but I do think that that the standards, at least the formal standards, are lowered. You know, the Section 182 standard of adequate protection, that's pretty flexible. I mean, it's not a rigid standard. And to then qualify, it takes on a certain meaning over time in terms of the various regulations and detailed decisions that are taken. But if you then qualify it with reasonable assurance, and I'm not sure this is what the questioner is asking, but in any case, you're watering down that already vague standard. And you know, I'll tell you, after I put my thoughts together, I got the Delphic Oracle, ChatGPT, and I asked them what did they think, and they thought it lowered the standards. So for whatever that's worth. Yeah, I think that's a problem. I think in general, the history of nuclear power has been finding the right standard, or like, is it good enough, rather than, in fact, the historian's book is called Safe Enough, ? I think one ought to always be improving, trying to improve. Now, you can't ignore economics, as was mentioned earlier, but still, you should always be thinking of improving your standards. And I think we've been going the other way here.
Thanks so
I'm not
much.
sure that answers the question, but.
Well, thank you, Commissioner. Alina?
Yeah, I'd like to comment on this. You know, first of all, I think most of us in the industry support the role of independent agencies. It's very important for the NRC to be independent in order to remain the gold standard for nuclear regulation, of course here, but also worldwide. It's also very important for stability and predictability for the NRC to have that independence. We cannot have political interference in the role of independent agencies like the NRC, because honestly, even for people and companies that want the NRC to be more flexible, more forward-leaning, under this administration, administrations change, right, and priorities change, and agencies like the NRC should really be outside of that. So I think that's a really important point to make. But the second point is the ADVANCE Act in no way directs the NRC to lower its safety standards, in my opinion. And I did want to say that the drafting was not done by legislative aides in a vacuum. There were a lot of people with significant experience in NRC licensing, NRC regulation that suggested some of the language, that worked with the legislative aides in the language. So it was one piece of legislation where you could see the involvement. It wasn't just some blue sky exercise where people came up with ideas. It was based on very practical application of how the NRC regulates. And also, if you look at the provisions, like the provisions I highlighted, there's nothing new here as far as standards. There's no lowering of standards. There's no moving of standards. It's really down to just the process. Most of this is process focused. I think the only one that you could say creates a slightly different standard is the loosening of the foreign ownership and control domination restriction. Everything else is really just about efficiency and timelines while still keeping that safety focus in mind. So I think it's really important to reiterate there's really nothing in advance that in any way affects the standards to which the NRC regulates.
And if I'll just pile on, I will just say that Commissioner Caputo's remarks, supported the current commission view on the role of deterministic regulations versus risk-informed regulations. And it's hard to argue with that. I mean, they are two different approaches to solving a problem, and sometimes one's better, sometimes the other's better. It's best to, be able to say deterministically, this is something I don't want to have happen, and then have a risk-informed whether or not that, what are the chances of that bad thing happening? What should I do? Where should I focus my attention? Should I spend more time on diesel generators or on main coolant pumps or whatever, you know? So I mean, there's an opportunity for both of them. They're answering different questions. So I don't see a lot of these questions on risk-informed and safety regulations seem to act like they're in conflict. And I think the commission standard is that they should work together, and I'm hard-pressed to disagree with the commission on that.
Thank you all very much. Emily, in your, Alina, I'm sorry, in your answer, you mentioned the foreign ownership, control, and domination issue. A question came in, by allowing FOCD of U.S. nuclear facilities to countries that are our, quote, friends, is there any concern that it may open the door for countries not currently on the, quote, good list if relations do change between countries later on?
Well, we're certainly in an interesting political environment today about who our friends are and who our friends aren't. But I think you can say that, you know, despite, some of the issues we're seeing today, the OECD countries are countries that with which we are currently allied, that we've been allied with for decades, and will continue to be allied with. So I don't really see any OECD country now kind of going rogue and creating an issue. We have a company that's somehow adverse to our interests. But I did want to reiterate that we still have that non-inimicality standard that applies. So when we are talking about getting rid of the FOCD restriction for those friendly countries, it doesn't mean that the NRC still can't review foreign control and ownership and decide that, let's say tomorrow Canada is our enemy number one, and a Canadian company investing into a U.S. Company that owns a nuclear power plant would be inimical to our standards. The NRC can still do that if the world drastically changes in the future. But here we're allowing for some flexibility where automatically these, we don't have an automatic denial of the ability of some of these companies from these friendly countries to invest in our nuclear industry and help support the operation as well as the expansion of the fleet.
Thank you. Emily, this question is for you. During your talk, you mentioned Chief Justice Roberts' discussion of personal liberty. What relevance does this have to an agency that the questioner asks, for the most part, only issues licenses to a finite number of parties and does not regulate the public at large?
I think that's a great question. One of the things that I've scratched my head over when I've been reading these judicial nods to liberty is, what do they mean by liberty in a given case? And so I want to appreciate what I think is behind the question, which was how is this even relevant here? And say that my reading of a number of the justices' idea of liberty is that it is vague and high level. It does not necessarily get into specifically how they think liberty is threatened by a specific agency in a specific proceeding. I can offer maybe a way to think of that in the standpoint of NRC license decisions would be the liberty of the operator. Maybe it's the liberty of the business interest that's appearing before the agency and that's regulated by the agency. That's a possibility, but the law that we're seeing right now, the court doesn't actually specify liberty, they just say it. And so this is why I see this as an attitude that informs how we're seeing a lot of these decisions coming out as opposed to a useful analytical tool.
Thank you. And now, for those who were watching the presentations yesterday and saw, I believe it was Commissioner Crowell referencing Monty Python, to bring that full circle, the reference in there of bring out your dead and I'm not dead yet, There was a discussion here about CEQ and being directed to withdraw its NEPA regulations. That's being done, but there was, as some of you may have seen, the DC Circuit decision, or the trial court in the DC Circuit decision, saying that CEQ was not authorized to actually enact these enforceable NEPA guidelines. There was a footnote in that case, though, where the court specifically said, we're not talking about an issue where an agency looked at our regulations and independently adopted them as their own. And so are the independently adopted CEQ regulations dead yet at other agencies like the NRC, which has done that? Or how should someone look at the enforceability or viability of those regulations?
Is that for me or Emily?
That's to whoever wants that one.
I will just say that it makes more sense for some of the agencies that have just simply adopted the CEQ regulations by reference. The NRC has issued its Part 51, and so if you go back to its standard, it will live or die on whether or not, when it issued those regulations, they were well thought through and otherwise, you know, persuasive and all those other great Skidmore factors. But they aren't in the same situation as some of the other agencies that just said, do what CEQ says.
They're not dead yet. So I think we agree on that. Here, I just want to remind everybody, agencies implementing regulations for NEPA are not interpretations of their statutory mandates. So these are not situations where Chevron ever would have applied. This is a place where I just want to bring back in my concerns about White House oversight of independent agencies. When is the White House going to call and say, we want you to change your NEPA regs? We don't like them. Right? That's the kind of place where I see a lot of potential implications for this White House exertion of authority over independent agencies. And so, no, they're not dead yet, but I predict a lot of pressure across a lot of independent agencies to change regulations like that to reflect White House preferences.
Thank you. I've got some more questions here, but I know, Judge Bulwark, you had a question that you wanted to ask, if you want to ask that now.
Just one quickly. Let me circle back to JARCASI. And Bud Hamer talked about this, and I think you hit it on the nail on the head in terms of the standards that the court looked at in terms of punitive rather than remunerative. This clearly, I don't think NRC civil penalties under Section 234 of the Atomic Energy Act are in any way remunerative that I'm aware of. Also, probably not public rights does not apply here. The cases have historically been exclusively executive or legislative, like revenue collection. That's not what we're involved with here. I'm sort of interested, though, does Atlas Roofing save the agency in this instance? And the Supreme Court talked about Atlas Roofing in JARCASI, where the agency, where it sanctioned agency adjudication of an agency-imposed civil penalty arising out of the Occupational Safety and Health Act for violations of a set of regulatory safety standards that had no common law basis. I don't think they were regulating nuclear power back in when the common law was the main thing everyone looked to. Does Atlas Roofing save the agency, or is there still a problem?
Well, and I think, Your Honor, that gets back to the question to ask about my spider pig analogy. The question is, if it's an agency doing what an agency is supposed to be doing and following the statute, then it's used to be just public rights. Now you look at what the agency is having the impact on the regulated community. And if that is a punitive fine, then it would be a punitive fine. I mean, for example, if you went to something like security, and you go back and say, well, the king was really worried about security in the 1790s, and it was an exclusive administrative agency, exclusive power, and he could tell people, you know, follow. If the Royal Navy says you're in trouble, I'm going to use my power to do it. Then I think you don't have a right, but or a jury right. But if it's more the sort of thing where the king is acting more like less like a regulator and more like a participant in the market. God forbid DOE should ever actually provide some services for spent fuel. That's the kind of example where, you might be able to say that's them acting as a commercial entity, that's the government not acting as the government, and then you're going to be much easier to have the argument that you're entitled to a jury trial for that punitive penalty. It's kind of bad to go into a contract with somebody and then have them be able to punish you if you don't follow the contract. Kind of contract law 101, usually it's not punitive. Anyway, I'm trying to stay at the asking questions mode, not answering questions.
Well, thanks.
Leave it to somebody else.
Anyone else want to weigh in on that? So I think this question is probably best directed to Commissioner Galinsky and to Alina. A question came in, and given the perspective that humanity needs energy, which, and by the way, we thank Commissioner Galinsky for running the AI search to boost the need for energy, so thank you for that. Given the perspective that humanity needs energy, doesn't the quote-unquote risk of nuclear need to be reasonable with respect to alternative energy sources? And I'll throw that out to the Commissioner or to Alina, but anyone else can join in too.
I think everybody wants reactors to be safe in reasonable terms. And, economics comes into these issues, but it depends on which stage you apply it. It's one thing to apply it when you're setting a basic rule, and it's another thing to apply it in application. When somebody violates a rule and you say, oh, well, it's going to cost the money, so we'll let them, violate the rule. And I think, I guess my basic answer is no, we want to have high standards. Just like with airplanes, we depend on them tremendously, but we want a continually increasing standard of safety. And that's the goal of the FAA. They don't say what's good enough. They say, let's have a standard that is better than anyone's and to have basically no accidents. Of course, in the real world, accidents happen, but your outlook should be to be constantly improving and even more so on things that you rely on a lot.
Yeah, I think once again, there's nothing in the ADVANCE Act that changes the standards. I do think it is important to have high standards, right? But the question is, how do we get to meeting those standards? It's that how do we get there that is being addressed here and that is being discussed here. Just because we've licensed large light water reactors in the same way for several decades in order to ensure that they operate safely and meet that standard doesn't mean that we have to license microreactors in the same mechanical way to meet that standard. So I think this is where some of the push comes to the ADVANCE Act and some other efforts, about really the mechanics of how we get there rather than changing the standard. And I fully agree, it is the need for clean, abundant energy, is greater than ever and will continue to increase, as we can see from all of the demand load projections. But I don't think we need to weaken the standard of the NRC in order to expand nuclear energy. We just need to regulate, in a smarter way, and it certainly can be done. And I have a lot of faith that the NRC can do it.
Well, let me just mention, consider the case of Japan. When we evaluated the safety, or they evaluated the safety of their individual reactors, no one, I'm sure, took it into account the possibility that they would all be shut down if you had a serious accident. So I think having very high standards is part of having this technology useful.
Thank you both very much. One final question directed to Bud and Emily, 30 seconds each, and you're on the timer. Have you seen trends in judicial decisions on an agency's responsibility to consider cost of regulatory actions?
Well, Michigan versus EPA that I mentioned was an exception to the Chevron standard, and now that it's freed from having to have a Chevron standard, to first go in, we will see. I mean, I think there is a big difference in past money spent and future money spent. And I think Michigan versus EPA says we should decide, when we're deciding on regulation, we should decide whether or not regulating this area is how much it's going to cost in the future. But necessarily the fact that they spent $1 billion to build it doesn't make it any more safe. But on the flip side of that is that if they spent millions of dollars designing a computer program, verifying it, and it was hundreds of people validating it, I think that computer program is probably safer than one that was written by 2 high school students in their garage. I mean, I think you can weigh the cost in that standpoint. And I think that there is a trend for considering cost as a tool in regulatory space and sort of doing the cost and benefit analysis.
I agree, it's a trend. I think it's been a long time trend, and we trace it back to the Reagan era with OIRA review and imposing cost-benefit analysis on the executive agencies. One thing about the Michigan decision is, although it stands for the proposition that in general agencies should consider both costs and benefits when they regulate, it left open the possibility for exceptions that Congress would establish, as well as it didn't tell agencies how to do it. So I think there's still a lot of flexibility there.
Well, I think that's about all the time we have. I want to thank our panelists, Alina Toplinsky, Commissioner Galinsky, Bud Hamer, and Professor Emily Hammond, for sharing their thoughts and perspective on this very timely subjects. Time will tell the ultimate direction that the courts will take on the impacts of the ADVANCE Act and the recent Supreme Court cases that were discussed this morning. I also want to thank the audience, both those of you who are here in person and those who are watching remotely, for your attention and for the thoughtful questions that came in. As we conclude, I have two items to pass along. One is that for those of you who will plan ahead, I mean way ahead, next year's RIC, the 38th annual RIC, will be held March 10th through 12th, and the ASLBP will be relying upon your feedback on this session in putting together a program for next year. So please submit your feedback by scanning the feedback QR code and sharing any thoughts or insights you might have pertaining to this session or to the RIC conference in general. I thank you all for your attention, and if we have nothing else, we stand adjourned. Thank you.